we discussed yesterday that we have six kind of fundamental rights, six fundamental rights at present. Out of that, the first one we discussed was right to equality. That is Article 14 to Article 18. Right? Equality or equity, what is there? We'll talk about that in detail. What is the difference between equality or equity? If anybody can throw a light on that, what is the difference between equality and equity? Seeing this image. Equality is in fact, generalistic or a negative concept. Equity is positive concept. Why positive? Here, the conditions will not be seen. Here, only equality means equality. This is kind of law. If law says that everybody is equal in front of the law, it will not see that what is your condition, your advantage or disadvantaged, whatever you are. But the concept of equity says that if somebody is not having that resource or somebody is deprived of any resource or any capability, he should be facilitated so that he can be at equal position with all others, right? So in this concept, that's why we call it a positive conception of equality. The positive conception of equality is known as equity, right? So on this note, we are going to start Article 14. Article 14 talks about equality before law and equal protection of law. Means right to equality. Simply, in our country, we have two kinds of conceptions. That is equality before law. One doctrine says equality before law, and the other doctrine says equal protection of law. If I say equality before law, what it means, and if I say equal protection of law, what it means. After seeing that image, is it not very clear that the first one, equality before law, talks about the concept of the negative concept of equality? Yes or no? While the second concept of equal protection of law is more closer to the definition of the word equity. Yes or no? This equality before law concept is negative in nature, and it was we got inspired about these this theory or this principle from Britain, because it is of British origin. While on the other hand, the equal protection of law is more of a positive connotation, and this concept was taken from US laws. USA. Getting it?
Yes, sir.
When we say ABL, equality before law, actually equality before law is one of the components, one of the elements or components of rule of law. Rule of law. This principle of rule of law actually was given by an eminent jurist, A.V. Dicey. Who gave the concept of rule of law? It was given by A.V. Dicey. He was a British jurist. He propounded this theory of rule of law. Right? And our Supreme Court says that rule of law is imbibed in Article 14. Is imbibed in Article 14. What is the meaning of equality before law or the rule of law? The meaning of these two words is actually law is supreme, law is king, law is everything. Getting it? Yes or no?
Yes, sir.
Law is everything. When we say equal protection of law, it also speaks that there is an absence of any special privilege. Nobody is privileged. Means equal subjection of all persons to ordinary law. Yes or no? We can also say that no person is above law. Is equal to equality before law. Yes or no? Or we can say absence of any privilege or special privilege in favor of any person. Any person. We can say it or not.
Yes, sir.
We can also say that it also tantamounts to equal subjugation. Everybody is subjugated, everybody is under law. These terms, these sentences, they will provide in the examination, and they will ask that which of these are the meaning of equality before law or rule of law. Equal subjection of all to ordinary law. Yes. While on the other hand, when we talk about equal protection of law, equal protection of law, it is a bit different. It is more of a positive, as we say, positive concept. Why it is positive? Because there is a equality of treatment, right? Under equal circumstances. Means we can say likes should be treated alike. Or we can also say that unlike should not be treated alike. Yes or no?
Yes, sir.
Like should be treated alike means if Paralympics is going on, all the participants should be differently abled, right? That means you are treating like there. You are disqualifying all those people who are completely able, who are completely normal. The person can say that you are doing certain kind of discrimination there. You are not allowing us to participate because we are normal. So there the concept is like should be treated alike, unlike should not be treated alike. One is given lathi in their hand, a bamboo stick in their hand, and the other person is given AK-47. Will that fight be justified? That fight cannot be justified because unlikes cannot be treated alike. If one is having bamboo in his hand, the fight should be with a person having bamboo only. Similarly, in wrestling also we see that the fight is among the equal weights or weight categories in wrestling and boxing. It is not that a weight of 30, 35 kg or 50 kg is fighting with the 90 kg. Unlike should not be treated alike. Got it? Yes or no?
Yes, sir.
But there are in India, neither the equal protection of law is completely applicable, nor there is a mix of both. We prefer actually equal protection of law, but legally you will find even equality before law is also there, or because of the concept of the rule of law being implemented in our country. We were a British colony. Already those laws were there, and we adopted all those laws. Sometimes we find it negatively worded. But courts in various interpretations have cleared those things and said that equal should be treated equal, unequal should not be treated equal, right? So state shall not deny any person equality before the law or the equal protection of law within the territory of India. This is the word which is used in Article 14. From this, we derive these two concepts, equality before law and equal protection of law. Equality before law, when we say, as we studied, it is a British origin. It is a negative concept, absence of any privilege in favor of any person in the eyes of law, equal subjection of all persons to the ordinary law, and no person is above law, right? Similarly, when we talk about rule of law means lex supremus, or law is supreme. There were concepts like rex, lex, lex, rex. Rex means regal, royal, king. King is law. This was the previous concept. Whatever king used to say, that used to be followed by everyone. So the words of kings were the law. This was lex principle. But nowadays, after the modern conception of law, after A.B. Dicey's rule of the law concept, we started adopting lex rex. That is, law is the king. Law is the supreme. Right? A.B. Dicey talked about this. Rule of law is implicit under Article 14, as it is said by Supreme Court, and it also declared that this is basic structure of the Constitution, or basic feature of the Constitution. Elements of rule of law, for your knowledge, if we say rule of law, there are many elements. That is, absence of arbitrary power. There should be no arbitrary power. Secondly, everybody is equal before the law. This is the second component. This component we were talking about. And Constitution is the result of rights of individual. In our country, we will see that the Constitution is formed by the rights of the individual. Means Constitution is the source of the rights of the individual. In our country. In Britain, you will see that Constitution is the result of rights of the individual. Constitution, we say that this is the source from where we derive the rights. This is Indian concept. What is British concept? Constitution has resulted because courts have declared various rights for the people. In Britain, courts have declared various rights for the people, and collecting those rights, they created Constitution. In our Constitution, what is the case? It is reverse. Constitution is the source of the rights. It changed the concept of administration from lex, that is king was law, to lex, that is law is king. We understood this? When we say equality before law, we say that it is not absolute. Not absolute means what? There are restrictions, or there are limits, or we can say there are exceptions. Yes. When we talk about equality before law or rule of law, is it absolute? No, it is not absolute. You will find your roads empty when some minister or some prime minister or chief minister or president is going. That means he is having some kind of privilege. There are privileges given. Even your constitution provides certain kind of privileges, like the president of India and the state governors enjoy certain immunities. Like no criminal offenses, no criminal proceedings, no arrest. They are not answerable to certain courts, etc., which is already mentioned in Article 361 of the Constitution. Yes, the President of India and the state governors are immune to criminal proceedings, arrests, and even they are not answerable to any uh, certain kind of courts, right? Certain kind of courts, some courts, civil cases, they have to answer with a prior notice of 2 months. Article 361 gives certain immunities, means they are now an exception to the law of equality before law. No person shall be liable to any civil or criminal court proceeding in respect to the publication in newspaper. Suppose you saw some incident and you narrated that true story in your newspaper or in certain newspaper or on radio or over YouTube channel, right? If the things you said are 100% correct, you are not liable to any civil or criminal code because you are telling a substantially true report of any proceeding of the parliament. Actually, parliament has barred everybody that nobody can speak about parliament except what the presiding officer declares, right? If anybody sees that picture, what is happening in the parliament, he was there in the parliament and he reports that in the newspaper, and that story is correct, not concocted, he is allowed. This provision was added through Article 361A. This is also a kind of exception to the rules of the parliament. Similarly, no MP or MLA shall be liable to any court proceeding in respect of anything said or any vote given by him in parliament or in the state legislature or in any committee. Means they enjoy certain kind of privileges, which is unequal actually, right? They are, if we say something publicly, we can be held liable for that if it is wrong, if it is against the nation, if it is against certain values. But a parliamentarian speaks in parliament anything and he goes scot-free. He is not liable to any court because of this protection that is given in Article 105 for the MPs and in 194 for the MLAs. This is exception to, again, equality before law. Similarly, you have Article 31C. Article 31C. It is also a huge exception to Article 14 and provides that laws made by the state for implementing the directive principle of state policy, Article 39B and 39C, cannot be challenged on the ground that they are violative of fundamental. If 39B, to implement 39B and 39C, that is law against concentration of wealth or law for the proper distribution of resources in the country, if those laws are done, suppose lands are taken from jamindars and given to the small landholders or the farmers, landless workers, it is a kind of inequality actually. Yes, you cannot take those land of those people who are not having, actually who are having little land, but a person who has earned a lot of land during the British era were devoid of their land or property. This was a kind of inequality, but this inequality was allowed. Means this was violative of fundamental right. To protect this violation, Article 31 was added as an exception to Article 40. Are you getting it? The exceptions part?
Yes, sir.
The last exception, the foreign sovereigns, ambassadors, diplomats, they enjoy immunity from civil and court proceedings, and UN agencies enjoy diplomatic immunity, right? foreign sovereigns, if they are coming here, kind of civil and immunity against the court proceedings. Even the UN agencies enjoy diplomatic immunity. Is it clear to all? Is this board clear to all?
Yes, sir.
Anybody? If he's like, yeah. Any question? Either the voice is not coming or you are not saying. Am I audible to all?
Sir, you are audible. Guys, see, sir is explaining you in detail. So do respond because it is both your mains and prelims part.
If you have any confusion, any kind of doubt, you can ask that question, because these are the concepts where confusion do arise, right? If there is any confusion, you can ask question. You can write it down. You can ask at the end of the class, at the end of the class. Yeah. Tell me.
Can we say the PSP and fundamental rights are both complementary to each other?
What was the question, Utsav sir? Did you?
Manav, sir is asking
Sir,
question.
I'm asking.
Manav, let me say something. Manav is asking this question, right? Manav, sir is asking
Yes.
any doubt with respect to Article
Yes, sir,
14
yes.
and the exception.
No, she may be right in saying this.
No, 31C है ना सर, इसलिए तो डायरेक्टिव प्रिंसिपल ऑफ स्टेट पॉलिसी एंड वो फंडामेंटल राइट्स तो कॉम्प्लीमेंट्री हो सकता है क्या दोनों?
Very genuine question. Very genuine question. I'm answering that. I'm answering that. Just hold on. Just see. Generally, fundamental rights are treated as superior laws because they are enforceable. First of all. Secondly, they are treated a bit sacred also. And thirdly, because of Article 13, which says that हमसे जो टकराएगा चूर चूर हो जाएगा. That means any law which is violative of fundamental right, any law which is violative of fundamental right shall become null and void automatically. Right? When you are implementing the provisions of Article 39B and 39C, these laws are actually directive principle of state policy. First thing, they are not enforceable in court of law. They are even given less value than fundamental right. They should be given less value. But Jawaharlal Nehru government brought this 31C amendment and declared that if 39B and C, while implementing 39B and C, if Article 14 gets violated, then it should not be treated as violation. Means 39B and C was given superiority over Article 14. Normally, Article 14 is a superior law, but when it is in conflict with 39 and B and C, this 39B and C shall be given more value. This was challenged time and again in the Supreme Court, but the Supreme Court said that when the government is going to create certain kind of social welfare measure to create equality in the society, actually there was, with the Jamindari system, there was certain kind of inequality existing in our society. To level that field, If the lands of the zamindars are taken and distributed to the landless laborers, it will actually ultimately create equality. Even if it is violative of Article 14, it is indirectly supporting Article 14. That's why these laws are given superiority over Article 14 and Article 19 as well. Right to property was there then. So superiority over Article 14 and 19. So her question was very genuine that fundamental rights are superior than DPSP. But when there is a conflict with 39B and C, the DPSP 39B and C are superior than Article 14 and 19. So we can create a kind of priority list. When we say fundamental right, they are most important laws. All fundamental right except 14 and 19 can be given the first rank. The second rank goes to Article 39B and 39C. These are the second most important laws. The third rank must go to Article 14 and Article 19 of fundamental right. Got it? All fundamental rights are superior except Article 14 and 19. They come at rank 1. Then comes 39B and C. Then comes 14 and 19. I hope you understood the point.
Yes, sir. Thank you, sir.
Equal protection of law, we talked about that. US origin, it is a positive concept. It does not mean that all laws shall apply uniformly among all persons under all circumstances. Rather, it means that the equality of treatment under equal circumstances, the similar application of laws, same laws to all persons who are similarly situated, as we can imagine that picture we started with today, right? The like should be treated alike. We have explained, we have done this. Okay. The next one. When we see equal protection of law, it only guarantees equality of treatment among equals. Therefore, states should ensure that people are placed in similar circumstances. Suppose a race is there. In this race, Mr. X is starting from here. Mr. Y is a bit lagging. He starts from here. And Miss Z, she is there. She is starting from here. The finish line is same for all. Who will win the race? It is very easy to say. X must win the race because he is more nearer to the target. This is the target line. So what? In such condition, what we need to do? We need to labelize this. The target for Z should be here. The target for Y should be here. If race starts now, it will be an equal platform for everybody now. Getting it? Or if she is a female, she is not physically that stout because of the biological make, her line should be in fact lesser than that. The length of the line should be, the distance of the race should be lesser than that. So if we are creating such situations, what we are doing? We are placing people in similar circumstances before applying a uniform law among them. Getting it? If we see the latest case of Indian Young Lawyers Association versus State of Kerala, that is Sabrimala case. In Sabrimala case also, this question came. The first question was, should women be allowed to enter to the Sabrimala temple in Kerala? Sabrimala is a temple which is situated and located in Kerala, in Sabrimala Hills. It is one of the most revered temple in South India, where God Ayyappan, Lord Ayyappan, is worshipped as a bachelor there. And there was a in fact, tradition which was followed since the beginning of that temple, that only non-menstruating women can enter into the premise of that temple. Male can enter and non-menstruating women can enter. Some women challenge this. They say that it is violation of fundamental right of Article 14, that is right to equality. We are not given equal treatment there only because of a biological drawback which we have, that we menstruate. Women between age 10 to 50 were not allowed to enter the temple. So this question was being asked based on the biological factor exclusive the female gender amounts to discrimination and thereby violates the very core of Article 14, 15, and 17 and not protected by morality as used in Article 25 and 26, that we have our own religious right to practice. In this condition, another question which was asked was whether the practice of excluding such women constitute an essential religious practice. Whenever there is a problem in the religion, that hijab should be allowed for the Muslim women or not, getting it? Or mutilation of female sexual organs should be allowed or not in certain Bohra community in Gujarat. The entry of women in the masjids like the Haji Dargah Masjid of Mumbai should be allowed or not. These all questions, whenever these kind of questions do come, court uses the test of essentiality. This test was derived or originated in Shirur Mutt case. Shirur Mutt case in 1950s. In Shirur Mutt case, the Supreme Court says that whenever there is a confusion that this practice of the religion should be allowed or not, test of essentiality should be done. That is this the essential part of the religion? Without the practice of this part, the religion will die. If it is so, then it shall be treated as the essential character. Because is everybody fine with the internet, my voice, or is it cracking?
Fine, sir.
Okay, thank you. Thank you, sir. In Shirur Mutt case, test of essentiality was given. Lot of questions started coming up during that period. That why Muslim hijab is not allowed, but the turban of a Sikh is allowed. Why a Sikh is allowed to have turban on his head, kripan on his back, kada in his hand, but a Muslim man is not allowed to grow beard in the duty. Suppose that there was a case from Air Force. There was an airman who, in fact, displayed beard in his duty, long beard. He came with long beard. He was suspended. Why he was suspended? Because the keeping beard in the Air Force was not allowed. So he challenged in the court that why the turbans are allowed, but his, in fact, religious sign of having long beard is not allowed. The Supreme Court again used this test and said that turban is an essential practice of Sikhism, but beard is not an essential practice of Islam. Right? So these kind of, in fact, religious essentiality test the court does. Similarly, these cases of Sabrimala are challenged again. The hijab case is challenged again. Right? Women entry is challenged again. The triple talaq is challenged again. The Supreme Court has clubbed all those cases together and it is hearing since last 2 years, but no result yet. Let us see. Almost 83,000 cases are pending in Supreme Court, which is highest ever. D.Y. Chandrachud, when he took the seat of Chief Justice of India, he said that my first priority is to decrease the case. Unfortunately, during his tenure only, the number of cases increased to 83,000 from 80,000. The pending cases. So I hope Article 14 is justified, and you all now understand the nooks and corners of Article 14. Yes or no?
Yes, sir.
Now
Yes,
we will
sir.
talk about Article 15, that is prohibition of discrimination on certain grounds. Right? Article 15 says that state shall not discriminate against any citizen. The word citizen must be marked. Against any citizen on grounds of only, this word will be, shall be marked, only religion, race, caste, sex, and place of birth. State shall not discriminate against any citizen. First of all, non-citizens can be discriminated on ground of only, means religious discrimination should not be done, racial discrimination should not be done, caste discrimination cannot be done, sexual discrimination cannot be done, discrimination on the basis of place of birth shall not be done, but other discriminations are possible. It does not prohibit every kind of discrimination. It prohibits discrimination only on these 5 grounds. Am I clear to all? The word only connotes that discrimination on other ground is not prohibited. Discrimination on other grounds not prohibited. Am I clear?
Yes, sir.
Right? Similarly, the properties which are either funded or created by state or state fund or for public purpose, like wedding huts, like restaurants, hotels, cinema halls, those are for public purpose. Discrimination should not be made in the use of those places. Suppose in British time, there was a dialogue that dogs and Indians are not allowed in the restaurant, in the hotel, in the swimming pool. These were the common boards we used to see before 1947. But now, the constitution makers clearly said that no citizen shall be prohibited from using general public use properties which are maintained partly or fully by state fund. Right? You can write, this is actually 15.2. I'll show you all those things. You can write from those places. This second provision, this is the first provision of the 15. Shall I erase this? 15.1 says that states shall not discriminate any citizen against on the grounds of only religion, race, caste, sex, place of birth. Right? It is enforceable only against the state and not against the individual. If an individual discriminates, it is my private office, and I'll say that, can I do that? Yes or no? If I am a private individual, I am having a private company, and in my private company, I am recruiting only males, suppose, or I am recruiting only people who are, I have a restaurant and I want to sell the concept of the restaurant, and in that concept, I have used that only deaf and dumb people will be recruited for the service. Can I do that? Yes, I can do that. Because this law is only against the state, not against the individual. But the second point, that is 15.2, talks about that no citizen shall be subjected to any disability, liability, or restrictions or conditions on the grounds of religion, race, caste, sex, or place of birth with regard to access to shops, public restaurants, hotels, places of public entertainment, or the use of wells, tanks, bathing huts, roads, places of public resort, maintained wholly or partly by the state fund. This is very unique. Wholly or partly by state fund, or dedicated to the use of general. If these things are made for the purpose of these like wholly or partly maintained by state fund, or it is dedicated to the use of general public, in those places, nobody can stop you, neither the government nor the individual. That's why enforceable both against the state as well as individual. This law in general was not enforceable against the individuals, but this law is particularly enforceable against the individual and against the state. Even the individual cannot stop people to enter into restaurant, hotel. You cannot make a restaurant in which you will allow only certain kind of people. There was a case, right? People in traditional dresses were not allowed in certain restaurant in Bangalore, I think. It was in Bangalore or Mumbai. Somebody filed a case and restaurant had to pay compensation for that. Getting it? Because of this law, 15.2. 15.3. 15.3 says, 15.1 and 2 created a condition that there should be prohibition of discrimination. But 15.3 says that it permitted to make any special provision for women and children. Means if the government wants to or needs to make certain special provisions for women and children, they can make it. That means the first kind of reservation enters into our constitution. And this was already mentioned in the original constitution. Original constitution, Article 15 had three subclauses, subclause 1, subclause 2, subclause 3. This is exception to the general rule of non-discrimination. Clear to all or not?
Yes, sir.
Yes, sir.
After yesterday, we talked about Champakai Dorairajan case, Champakam Dorairajan case of 1951. After that case, Article 15.4 was added by the First Amendment Act. This law was added in 15, and special provision for the advancement of the socially and educationally, mind these two words, socially and educationally backward classes of the citizen for the scheduled or for the scheduled caste and scheduled tribe. Means those people who are socially and educationally backward, or he belongs to SC or ST community, he or she may be given special provision for their development. Means the reservation in the educational institution started after the First Amendment Act introduced 15.4. This is again the exception to the general rule of non-discrimination. This was added by First Amendment Act 1950. Clear to all?
Yes, sir.
Next, when we talk about 15.5, again, this is also an exception. This is a special provision for the advancement of socially and educationally backward classes of citizens and for the scheduled caste or scheduled tribes regarding admissions to the educational institution, including private educational institution, whether aided or unaided by the state. There, in the educational institution, quota was fixed. 15.4 fixed the quota, right? 15.5 says that even in the fees also, in the process of admission also, in the merit list also, they will get certain kind of reservations. Even in the private educational institutions, right? Whether aided or unaided. Aided means funded by the government, unaided means not funded by the government. But this law does not apply to, means minority education institutions are not liable to give reservation to socially and educationally backward or the SC/ST people. Got it or not? This is again exception to the general rule of non-discrimination, right? This was added by 93rd Amendment Act 2005. This was not found in the original constitution. It came quite late in 2005 when right to education was being implemented. During that period, 93rd Amendment came in and it introduced Article 15 ka 5. Recently, another amendment was made in 15 and one more clause was added. What was that clause? That clause was regarding the economically weaker section of the society. Advancement of economically weaker section of the society. A 10% reservation was being made by 103rd Constitutional Amendment Act in 2009. This is the latest development in Article 15. Special provision related to their admission to the educational institution, including private educational institution, whether aided or unaided by the state. Other than, but this does not apply to again whom? Minority education institution. This does not apply to minority education institution. It will apply to all other educational institutions. Is Article 15 clear to all?
Yes,
Then
sir.
comes
Yes, sir.
equality of opportunity in public employment. When we talk about public employment, that means jobs, right? It provides for actually equality of opportunity. Opportunity. Whatever opportunity is created by the state for all its citizens, for all citizens. In the matter of actually employment or appointment to any government job, you can say office under the state, no discrimination for employment should be made on the grounds, again the same grounds, right? Similar grounds. No discrimination for employment under state. Mark this word, under state means government jobs. Government jobs. On grounds of only, again the only word has come. What are the grounds? Religion is one ground.
Race,
Race, very good.
caste,
Caste and sex,
place of
place
birth,
of birth,
residence,
or residence. You can include in this residence also. And one more is there. That is descent. Descent. Right? If he is descendant of somebody or like that. In Article 15, we noticed that there was religion, there was race, there was caste, there was sex, there was a place of birth. The word residence and the word descent was not there. Means these two new grounds have entered in Article 16. Right? But again, there are exceptions. Article 16(1) and 2 creates 1, 2, and 3 creates provisions, but Article 16(4), 16(5), 16(6), 16(4)(a), 16(4)(b), they all create exceptions. The first exception which we study in this is place of birth. Can any state government say that I am Haryana, I will recruit 70% of the people who are getting salary less than 50,000 in private sector? The company must recruit a Haryanvi people, means a citizen or the residents, not citizen, a residents or domiciled person of Haryana origin? Can they ask that? They have asked actually, and that case is still in the Supreme Court. Article 16(1) says that there shall be equality of opportunity for all citizens in a matter of employment. 16(2) says that no citizen shall be discriminated on these grounds when there is an employment under the state. Then comes 16(3). 16(3) again says that this is the first exception. Parliament can prescribe residence as condition. Residence can be provided as a condition. But who can provide this condition? The Haryana government or the Parliament? Haryana government cannot do that. Residence as the condition can be prescribed only by Parliament for certain employment appointment in a state or union territory or local authority or other. This was done actually for almost 20 years, 1954 to 1974, I think. A law was made by the Parliament, and residence as a condition was prescribed as one of the criteria in employment. But this was removed after 1974 and never implemented again by the Parliament. Parliament has made this law only for once, and that too for 20 years. Okay. Then comes Article 16(4). 16(4) says that state can provide for reservation of appointment of post in favor of any backward class that is not adequately represented. Means backward classes reservation is provided already in the 16(4) since the beginning of the Constitution. 15(4) was not there since the beginning of the Constitution, but 16(4) was already there in the Constitution, right? So there are a lot of exceptions getting created. First, the Parliament can prescribe residence as a condition. Second, reservation of appointment for the backward class people. And the third restriction, or we can say the exception, was a law can provide that the incumbent of an office related to religious or denominational institution or a member of its governing body should belong to a particular religion or denomination. Suppose there is a church and the church wants person from Christian society must be recruited as the pastor or the father of that denomination, or a temple recruits a person from certain Brahmin category, that was allowed. Brahmin or Hindu or whatever, right? That was allowed. These religious denominations were allowed to have their system. It was very fair, actually. Why it was fair? Because if a person of different religion is allowed to be appointed as denominational head of certain other religion, that will create chaos in the society, diverse society like India. Again, 16(5), after 16(5), 16(6) was added recently, amended by Article 100, Amendment number 103rd, Constitutional Amendment 2019, 10% reservation for the EWS, right? It is for religious denomination, and this is for backward classes. Got it? I hope you understand all the exceptions that are given in Article 16.
Yes, sir.
Yes? Yes or no? Am I audible?
Yes, sir.
Yes, sir.
Audible, sir.
Similarly, 16(4)(a) was added by 77th Amendment Act 1995. What it says, it empowers the state to provide for reservation in promotion. This was for reservation in promotion of any service under the state in favor of SC. Means SC, STs got a reservation in promotion, and no concept of creamy layer was there. Later on, latest in the Pavitra case, in the Supreme Court in the Pavitra case has recently allowed the concept of creamy layer in scheduled caste, scheduled tribe also. We'll talk about that also while talking about reservations. Article 16(4)(v) says that it empowers the state to consider unfilled reserved vacancies of the year. You can write one word here: backlog system, backlog vacancy system. Suppose there were 100 seats. Out of that 100 seats, 50 seats were for the unreserved category and 27 seats for OBC, 15 seats for SC, and 7 seats or 8 seats, suppose 7 seats for ST. The vacancy was like that. But scheduled tribes in many states are not at that stage. They have not developed yet to take the advantage of that vacancy. Even in IITs, you will find the seats of professors which are reserved for ST candidates, they are vacant. There was a time when ST seat used to remain vacant in IITs also. So they did not find candidates from ST category or SC category. Suppose they find only 5 candidates, 3 for SC and 2 for ST. That means out of the 22 seats, 17 seats went vacant. Right? What the government used to do was, they used to bring out next vacancy. Suppose there was 100 vacancy in the next year. They used to add this 17 vacancy. It used to become 117. And this 117 was distributed among the unreserved, SC, ST, and OBC. Got it? Who is at loss then? The SC, ST people are at loss because this was their seat. This 17 seat was dedicated to them. But that is now distributed among all. They will only get a meager amount of that seat. So the government brought an amendment and they said that if 17 seats are unfilled last year, they should be brought in a separate vacancy that should be known as backlog vacancy. And only SC, STs should be allowed to participate in these 17 seats. And they should also be allowed to participate normally in the 100 fresh seats. Right? It ends the 50% ceiling. Now the 50% ceiling of reservation in backlog vacancy is not allowed. Because in the Indira Swani case, the Supreme Court said that in 1992, that reservation must not cross 50% mark. But if a candidate from SC, ST, OBC is also given this 17 seat, this ceiling gets, in fact, violated. So in that scenario, for backlog vacancies, this ceiling limit was removed and this backlog system was allowed. This was brought in 81st Amendment Act 2000. Is it clear to all?
Yes, sir.
I'll take 10 to 15 minutes more, almost 10 minutes to finish this 17 and 18, right? Please bear with me. Article 70, it talks about abolition of untouchability in our country. Untouchability is abolished and its practice in any form is forbidden by this law, right? And this shall become a punishable offense in accordance with the law. Means you have to make law to make it a punishable offense. You have to make law. It shows that if you are saying that law should be made for this, that means this Article 17 is not self-executory. Yes or no? To execute this law, you have to make another law by the Parliament. Article 17 is available against private individuals also. It is not only the state which will not practice untouchability. Even private individuals are also not allowed to practice untouchability. Right? It is the constitutional obligation of the state to take necessary action to ensure that this right is not violated. Untouchability word is not defined in the constitution. Mysore High Court defined it. It refers to the social disabilities imposed on certain class of person by reason of their birth. Since they have taken birth in certain family or certain caste, because of that, certain social disability is applied on them. If this is the case, they can be treated as untouchables in the society. Does not prescribe any punishment for practice of untouchability, but Article 35 confers the power on the Parliament to prescribe punishment by law. So, using Article 35, Parliament can make law to abolish untouchability. Got it? Yes or no?
Yes, sir.
Yes, sir.
What you have to keep in mind about Article 70? You have to keep in mind three things. That it forbids practice in any form. Second is, it is not defined. Third is that it is also available against the individual. And the fourth is, to apply this law, the Parliament has to make law under Article 35. Got it?
Yes,
Then
sir.
comes abolition of title. Abolition of title. It prohibits the state from conferring any title. State cannot confer any title except what? Military
Academic.
title, academic, very good, academic, right? The military or academic titles are allowed, like doctor. You did your PhD in something and you want to put doctor in front of your name, you are allowed to put that. That is an academic. You earn through your education. Similarly, military titles, lieutenant, colonel, brigadier, these are allowed to hold, right? It prohibits the citizens are prohibited from accepting foreign titles from any foreign country. Then how come Dilip Kumar got Nishan-e-Pakistan from Pakistan? How? Lot of almost 12 to 13 foreign titles were received by PM Modi. But there is an exception to that. If they want to accept any title, they have to take permission from the president. After taking permission from the president, citizens can accept foreign title. Okay? Similarly, if any foreigner is in your country, like an ambassador is there, Eric Garcetti from USA is there in your country. If he is going to receive any award from a foreign nation, he must inform the president and get the consent of the president of India. No citizen or foreigner who are holding any kind of office of profit under the state, they cannot accept any kind of gifts, presents, awards without the consent of the president. Got it? Yes or no?
Yes,
No
sir.
title being a military or academic distinction shall be conferred by the state, except being military and academic. No citizen of India shall accept any title from any foreign state. No person who is not a citizen of India, not a citizen means ambassadors and all, without the consent of president, they also cannot take any award. No person holding any office of profit or trust under the state shall, without the consent of president, accept any present emolument or office of any kind from an ordinary or any foreign state. Got it? A lot of questions come when there is a case of awards, right? The Bharat Ratna, Padma Vibhushan. Suppose I got Bharat Ratna and I am using My name is Chandrasekhar, Bharat Ratna Chandrasekhar. Can I use that? This case came up in 1996, Balaji Raghavan versus Union of India. In this case, the Supreme Court upheld the constitutional validity of national award, said that Bharat Ratna, Padma Bhushan, these can be given to the common people. They should not be used as suffixes or prefixes. But you cannot use, when you are writing that you have got the Bharat Ratna, you can write your name and below that name, Bharat Ratna awardee. Otherwise, they should be forfeited. The Parliament so far has not enacted any law prescribing punishment for violation of Article 18. Thus, Article 18 remains a declaratory provision under the Constitution. It is a kind of directive. What Indian government can do if you violate Article 18, what Indian government can do at the max? Yeah. Take away your citizenship. That is the maximum government can. So today we understood Article 14, 15, 16, 17, 18. Very important article for prelims as well as main. If you have learned it in this detail, you can handle any kind of bouncer question, because if they want to create bouncer question, this is the place they play actually, and they have lot of scope to play here. Just to recall your, in fact, informations and to put the things in order, you can say that right to equality is mentioned in Article 14, 15, 16, 17, 18. 14 talks about equality. 15 talks about discrimination should not be there. 16 talks about opportunity. 17 talks about title. And 18 talks about, 17 talks about untouchability. 18 talks about title, right? If you remember this word, adult, means wrong spelling of idiot, adult. If you remember this word, you will get the chronology correct. Equality, discrimination, opportunity, untouchability, and title. Got it? Yes or no?
Yes, sir.
Similarly, we will
Yes,
be
sir.
studying. We will be studying Article 19 of the Constitution. 19, 20, 21, 22, 23, 24, 25, 26, 27, 28. Tomorrow, these are the articles we are going to study. 19 makes you Samrat. Study like this. S-A-M-R-A-T. The real spelling, the real chronology is this. But to remember this, I have made like this. Freedom of speech, freedom of assembly, freedom of movement, freedom of residence, freedom of association, and freedom of trade and profession, right? So 19 makes you Samrat. How it makes you Samrat? Tomorrow we are going to understand that. Any question, if you do have, tomorrow is Saturday, I'll talk to sir if there is a class. Any question, if you have, you can ask.